Federal courts have jurisdiction in disputes of citizens of different states where diversity is complete, meaning that no plaintiff is from the same state as any defendant, and that there is $75,001 in dispute. Now, parenthetically, states for diversity purposes include DC, Puerto Rico, and the federal territories. Citizenship for diversity purposes generally refers to the domicile of an individual, or, in the case of a corporation or other business, the state of incorporation for corporations, and the principal place of business. Every person has one and exactly one domicile, and thus is a citizen of one state for the purposes of diversity jurisdiction. If a person has two houses, note that the one he intends to make his permanent home is his domicile, and therefore he is a citizen of that state and not the other one, for the purposes of diversity. Businesses, however, can, and often do, have two or more citizenships. They might be incorporated in one state and have the principal place of business in another state. This is very common, as we mentioned before. In the case of Delaware, there are a lot of corporations incorporated in Delaware and do no business there. A corporation might be incorporated in multiple states, in which case it'll have multiple places of places of citizenship. Every place that it's incorporated is a place of citizenship for diversity jurisdiction purposes. But a business only has one principal place of business. And that's where the high-level officers control the business's activities. It's typically, but not always necessarily, where the headquarters are located. Now let's say your fact pattern gives you an example where the business has multiple places where the high-level decision makers make decisions in different states. You have to pick one. So you're going to look at the facts, decide which one is most important. That is your principal place of business, and there can be one and only one. However, as we mentioned, there might be multiple places of incorporation, and the corporation will be a citizen of each of those states. The $75,001 threshold can be met by adding together the sum of all of the claims. So if the plaintiff brings 4 claims, each of which is for just $20,000, the suit altogether is worth $80,000 and is thus eligible for diversity jurisdiction. We typically take the plaintiff's word on assessing the value of the claims for the purposes of diversity jurisdiction. So if he tells us in his complaint that each of his claims is worth $20,000, we're probably going to believe him rather than making our own assessment. After all, there is that much in dispute. Doesn't mean that he's going to win that much, of course. The exception is if the plaintiff gives us a number that is blatantly ridiculous. If the plaintiff says it's $20,000 in dispute, and we can tell from reading the complaint that there's $20 in dispute, we're obviously not going to take the plaintiff's word for it. Now that's traditional diversity jurisdiction. In certain class actions where 2 people in the dispute are from different states and disputes of more than $5 million, there is diversity jurisdiction despite that the diversity is not complete. Again, the rule was 2 people in the dispute are from different states, despite that many others might be from the same state. That means for these class actions, as I said, you don't need complete diversity. Similarly, you don't need complete diversity in the interpleader cases in many cases. We're going to discuss interpleader later. I want to save it for then. Generally, you should assume that we always need complete diversity. And particularly if your professor doesn't make a big deal out of these exceptions. When you see a diversity question on your exam, you're going to assume we need complete diversity. Diversity is an easy issue to test, and if you know the rules, an easy question to get right as long as you're in tune with them. So let's practice. Listen closely, there's going to be a lot of parties. John, Jack, Jill, and Jordan sue Billy, Bob, Brenda, and Betty in federal court for $1 million. I'll go over the parties again as we go through the states. The plaintiffs: John is from Florida, Jack from Illinois, Jill from New York, Jordan from California. The states are Florida, Illinois, New York, and California. Billy is from North Carolina, Bob is from Florida, Brenda is from New Mexico, and Betty is from Arizona. Those states, North Carolina, Florida, New Mexico, and Arizona. Is there diversity jurisdiction? Well, we meet the amount in controversy requirement. $1 million is certainly more than $75,001. But they failed the complete diversity test because John, a plaintiff, is from Florida, and Bob, a defendant, is also from Florida. No complete diversity, even though all of the other parties are from different states. An interesting caveat: nominal parties do not destroy diversity jurisdiction. This is an exception to the general rule. It comes up fairly rarely, but it's important to know in case you do see it. Let's keep things simple this time. John is from Florida, sues Billy from North Carolina for an auto accident there for a $100,000 claim. Diversity jurisdiction exists. We meet the $75,001 test, and diversity is complete. John learns that for some procedural reason, local to the state of North Carolina, he needs to add Billy's insurance company as a defendant. The problem is that Billy's insurance company has a principal place of business in Florida. Doing so will destroy complete diversity, because John is also from Florida. So we're now going to have a plaintiff and defendant both from Florida. That should destroy diversity jurisdiction based on what we've said until now. It turns out that it's okay, and we're going to allow that case to continue as long as the new party, doesn't have to be new, it can be named at the time of the complaint, by the way, but the nominal party has 1, no financial or legal interest in the case, and 2, does not take an active role in running the litigation. They're just kind of there, need to be there for some reason, but not doing anything. Again, they have no financial or legal interest, and they're not taking an active role in running the litigation. Diversity is assessed at the time that the plaintiff files his lawsuit. John from Florida sues Billy from North Carolina in federal court using diversity jurisdiction. After he files his complaint, Billy picks up and moves to Florida in an effort to destroy jurisdiction and force the case into state court. No luck. Since John and Billy were diverse at the time the suit was filed, diversity exists, and Billy can do nothing to upset that. This really makes a lot of sense. If we would allow jurisdiction to be defeated after the fact, defendants would have a lot of leeway to play games, kill cases like this, just because they don't like something that's happening in the litigation they want to do over. Litigation must be able to go on at some point. But there are a couple exceptions to this rule. For example, if you have to add a party to the litigation who is indispensable to the resolution of the case and is therefore required by the rules of federal rules of civil procedure, we're going to discuss later, if that person breaks complete diversity, this new party, this party that you have to add that is indispensable to the litigation, now breaks complete diversity, the court is going to lose jurisdiction. The theory is that he should have been there from the beginning. And that is, you shouldn't have had subject matter jurisdiction, diversity jurisdiction, from the very beginning. By implication, if you add a dispensable party, that is a party that doesn't need to be there under the federal rules, that will generally not defeat jurisdiction. The case will go on, even if that dispensable party is from the same state as a party on the other side of the V. Also, if a case is removed from state to federal court, another example to the general rule on timing, we're going to discuss diversity shortly, diversity is assessed at the time the case was filed in state court, that's the normal rule, and at the time of removal to federal court, which means we're going to assess diversity twice in removal cases. Now, why diversity jurisdiction? Why do we have such a rule? That's actually a very difficult question to answer, and I don't have a good one for you. There isn't much consensus about it. One common answer is that state courts have an incentive to be hostile to out-of-state residents. Thus, it seems fair to enable people from different states to access a federal forum so they can avoid the state court issues. But there are a lot of problems with that rationale. It certainly doesn't explain all of the rules of diversity jurisdiction. Indeed, diversity jurisdiction is a bit of an anomaly. Nevertheless, it's been here for a long time, it's probably here to stay, and you're going to need to know it for your exam.